off we go. I'm greeting you all at our second seminar. Which is dedicated. Just a second. Okay, our seminar in our module, which is dedicated module Fight Against Corruption. This is our second seminar in spring 2020. Okay, we have covered already a few topics. We've covered conceptualization of corruption, specialized anti-corruption agency. Now we're dealing with the criminalization of corruption. Okay, and a few lectures we conducted in this area. Now we are dealing with the seminar part. Please note that seminar is not only for you just to answer and demonstrate how you understood it. So long as we're doing our distant learning, this is also an opportunity for you to ask questions, whatever you didn't understand. So take the opportunity and ask your questions. Is that all understood?
I will have a question at the end.
You can actually, you're free to ask question anytime. If you want to leave it till the end, then we will leave it till the end. But if you want to ask it now, you're most welcome to ask it now.
I think after the questionnaire, we can understand it well.
Okay. Okay. Don't forget, I will be grading you as for the results of this seminar, and our task is not to demonstrate that you understood everything. What I will grade is your effort to study and understand material. So I may grade not only your demonstrated full understanding of the topic, but I can grade you by the nature of the question, okay, that you ask, so that your question will demonstrate your effort and your attempt to understand everything, okay? Is that understood?
Yes.
Yes.
Okay, so we have 6 questions. Last time we have 2 participants out of 3. Is Ravshan here?
No.
No, he's not here. Did you actually notify him via other means of communication, like WhatsApp or phone maybe? Did you try to reach him on his phone?
I phoned you, but you don't answer.
You phoned who?
Yes, I phoned him, but
Ravshan.
he
Okay,
yes,
he's not. So
he didn't answer.
Okay, he keeps missing our seminars.
Yes.
Okay.
Switch off. His telephone is switch off.
Okay. Okay, never mind. So last time it was you, Farid Ahmadov. You started with your choice. So if you don't mind, today we'll give the first choice. The first in order will be Aytaç Süleymanova. Okay. Aytaç, which question would you like to answer?
Which question? I think we can answer the questions in sequence.
In sequence, yeah, of course. Well, I give you order the preference, so you start first, and I give you a free choice to pick up question and answer it.
Okay. I think we will answer the questions and we will add our opinions when even another participant answers the question. So okay. I want us to answer the questions in sequence. Okay.
Which question? There are 6 questions.
First
question. Okay. The first question is on the screen, right? You can see it too.
How the international instruments defines the process of the incrimination of public sector corruption in Azerbaijan? Which instruments there? Okay. First of all, I want to say that the UNCAC, United Nations Convention on Corruption, requires the states to establish a body or bodies to ensure the prevention or law enforcement functions over the corruption. According to the requirement of UNCAC, the states established such agencies and ensured their coordination. The first specialized agency in this field was established in 1974 in Hong Kong's Independent Commission Against Corruption. Going beyond of this commission, the states began to establish such agencies, and such agencies divided to the three fields according to their functions. Main functions of these agencies are prevention. First of these agencies is mixed functional law enforcement and prevention functional agencies. Then only law enforcement functions agencies, and then prevention coordination agencies. These agencies must include the functions of prevention, elaboration of their levels of anti-corruption measures, and coordination of the internal commissions in the state. In Azerbaijan, we have two main agencies, the Commission on Combating the Corruption and the Anti-Corruption Department near the Prosecutor General.
Aytaç, I will need to interrupt you here. You are saying everything correct. You're saying whatever you said correctly. And indeed, this establishment of specialized anti-corruption agencies is a part of the general anti-corruption strategy. Okay.
Yes.
So it's good that you mentioned that. But the question is specific, actually. You picked up the first question, which is dealing only with specific area of fight against corruption, and it's criminalization. Okay, by criminalization, as you know, we mean that countries are describing in their criminal legislation actions which they subsequently they provide them with sanctions. They penalize these types of behavior, the actions with sanctions, and that is the process of criminalization or incrimination. So can you be more specific, please, and tell me how exactly the international instruments they affected this process of incrimination in Azerbaijan, of corruption in public sector? In particular, first of all, tell me please, was this process of criminalization of corruption offenses something which was happening nationally, or it was affected by international developments? If it was affected by international developments, which international instruments played a significant role in this process? Is that clear?
Yes, now. I would say the criminalization of corruption in Azerbaijan, this process was developed in order to the international requirements of international conventions. First of all, the UNCAC, United Nations Convention on on the corruption. Then the OECD Convention, Criminal Law Convention on corruption. These conventions involves the corruption actions, and Azerbaijan, the report of the OECD, in the report of the OECD 2013-2015, it was mentioned that Azerbaijan criminalized almost all of the actions of corruption in except the illicit enrichment. In Azerbaijan legislation, criminal legislation, these actions included to the under one chapter of the penal code, and crimes against service, interests of service, and almost all crimes against crimes on corruption mentioned in this chapter. Only the embezzlement and misappropriation was settled in another chapter. And also in the questions we will see the another action, criminal action, the fraud by the public official, using its public position. This also is a it is an issue that this crime should be replaced to the chapter crimes against service. And only I can say only illicit enrichment didn't include it to the our criminal legislation, our penal code, but almost all crimes criminalized. And according to the requirement of the international conventions, in particular, Criminal Law Convention on corruption.
Okay, you mentioned Farid's video is not on, as I see. Huh? Farid, your video is not working.
It's not working.
No, it's not working. You forgot to switch it on, and we can.
I switch on now.
Okay, we see only half of the face of iTouch. If you can just pull down your screen a little bit. Okay, that's good. So you mentioned this. Okay, great. You mentioned this convention on this convention of the OECD on the bribery of foreign public official in commercial transactions. Is Azerbaijan part to this convention?
OECD.
Farid, would you like to answer that question?
The Republic of Azerbaijan ratified the Criminal Law Convention of Corruption.
Of which was
Criminal Law Convention on Corruption, and
what about OECD Convention? Is Azerbaijan party to this convention? Okay, I'll answer it for you because Azerbaijan is not member to this convention, because it's a convention specifically for the members of this organization, and Azerbaijan is not part of the OECD, although it's under evaluation of some network, which is an affiliated organization, right? Affiliate, like cooperating organization with the OECD. OECD convention, it can be acceded by other countries, but Azerbaijan is not among them. So Azerbaijan is member to two international instruments. One of them is actually regional, right? One of them is regional. One of them is regional. Can you see me? Hello?
Yes.
yes.
Okay. Yes, Azerbaijan is party to this instrument. So these two instruments they have certain type of effect, right? They decided the process of incrimination of corruption in Azerbaijan. Can you answer this question, which regime of supervision they envisage? But be very brief, please. How do they ensure that the provisions of these conventions are implemented at an appropriate level? Do you understand my question?
No.
Okay, we have two international instruments, right? UNCAC and Criminal Law Convention on Corruption of the Council of Europe. Can you describe me the mechanisms which ensure that the provisions of these international instruments are properly implemented in Azerbaijan? Aytaç mentioned the IRG review report of International Review Group on the compliance of Azerbaijan with UNCAC, and she said that that this report considered that generally the Azerbaijan is successful in implementation of the UNCAC provisions on criminalization, right? So the second one is Council of Europe's Greco, right, which is supervising the implementation, among others, of this Criminal Law Convention on Corruption. Okay, sub-question number 3 in question 1. Are there any difficulties in them? And among difficulties, I specifically left this open in a general manner. Aytaç mentioned that illicit enrichment hasn't been implemented by Azerbaijan. Which other types of difficulties can you mention?
Difficulties. For example, I had a difficulty in the differentiate the actions from each action. For example, misappropriation of the official duties, official power, and the fraud.
Okay, you're switching now to question number 6, right?
6. Yes.
Okay. I was asking about the questions, but I mean, I'm generally satisfied with your answer to question 1. It's okay. We will speak about this differentiation with fraud in due course. Now, Aytaç, we will give the floor to Farid. Farid, which question would you like to, or unless you want to add something to question number 1 or ask any question concerning what we have already spoken about, would you like to pick up the next question?
I want to answer the third question. Please outline the main types of behavior in active and passive bribery, offer, promise, and so, okay.
Okay.
First of all, I want to say that yes, and this bribery and active and passive bribery is reflected in the title of our penal code, and also I want answer first passive bribery. First of all,
Farid, let me interrupt you here, okay?
Yes.
You picked the question number 2, right?
3.
3. Okay, sorry.
3.
And okay, go ahead then.
And 3. And the one of the passive bribery is the one of corruption offenses. And first of all, I want to say there are actus reus and mens rea. The mens rea of passive bribery, including intentional, these crimes will be committed only intention. only intention, and also including.
Okay, you've just mentioned the form of guilt, right?
Yes, form of guilt.
The form of guilt is
Also,
only intention.
yes, only intention,
Okay,
not
correct.
be committed by negligence, and one of the element of actus mensrea is the subjective element of this crime, and actus reus is the object element of this crime, and the main element of actus reus is perpetrator who participate in this crime. Perpetrator of passive bribery is only official, is not only ordinary people, and also including the next element is in incentive element, including under advantage, under advantage for himself or herself, or another person or entity. Also, under advantage may be everything. The main element of under advantage, better position before he was her, or the next element of under advantage
I'll just
is.
interrupt you here. I'll just interrupt you here to make it a bit difficult for you, okay? Not comfortable. And I'll just try to switch to iTouch. Okay. I'm trying to switch into iTouch. iTouch, can you hear me?
Yeah. Yes.
Can you just tell me briefly what can be considered as an undue advantage? Because Farid said that everything, whatever makes public official be in a better position than he was before that corrupt behavior, could be considered undue advantage. So can you tell me what can be undue advantage?
Undue advantage can be anything tangible or intangible. For example, maybe a bag of cash, maybe
yes.
The transaction over the money from one bank account to another bank account, or
loans, holidays, food and drink.
Yes, privileges, maybe concess, maybe.
Can you just perhaps each one of you give me an example? Now think and give me an example, please, of something which is immaterial and which cannot be evaluated like in monetary terms, which doesn't have like a specifically expressed monetary value.
Maybe you mentioned in the lecture that, for example, in the queue, in the court, using of the position, a person interrupts the queue and getting first the place of first, and this is also the I think a pattern to the advantage, maybe, or suppose career, maybe.
Okay, I think that's enough. Maybe Farid gives us another example.
Under advantage, maybe loans, holidays,
yes,
food and drink.
Loans and holidays, they can be
yes.
defined in monetary value, right? You
yes.
can actually measure them and say how much they're worth. Just can you please use like your imagination and tell me what cannot actually be evaluated in monetary terms?
You mentioned in the lecture the sextortion,
okay.
And I
get
the full definition of this notion. I understood something, but I can't know that this is true or false.
You didn't understand this term, or you just didn't understand what like how it's relevant to our topic?
I could not get the definition first.
Okay, okay. So let me clarify it for you. Sextortion means, well, it's a term, fancy, unfortunately, in a not in a good way, fancy, but it's because it's becoming, it's falling into the spot of public attention, of public international attention. It's composed of two words. It's about sex and extortion. You know this, right? First, we know what it is. Second is when you actually demand something using menace, threat, or force. You actually demand it, okay? Solicit it. So public officials, they can actually solicit and get different kinds of sexual favors from people.
Yes.
Okay, in exchange for something, something which is they are going to provide, or they provide actually. Okay, and it's a false understanding that the victims of it can only be women. It's not correct. Okay, we know that even men can be. And perpetrators can either be either man or woman. They can perpetrate this crime. It's actually a general term, much wider term, but it's especially important in the context of corruption. Okay, it's important, and especially in Azerbaijan. I said this in many at many meetings and many forums and during a few discussions, that in Azerbaijan, at the time when we have a greater integration of women into different public positions, right, at all levels, in all areas, there is a great risk of this phenomenon. And also, one shall not consider it as only a form of a passive corruption, right? It can be active corruption as well. So it's not about only demand, but it's also about supply. Okay, most of the time the biggest ignorance and the biggest problem in treating corruption is that it's only considered from one angle, from the angle of demand. Okay, and in order to effectively fight against corruption, one has to take into account the supply part as well. So it's equally important not only to cut the demand for bribes, undue advantages, it's also important to cut and reduce or suppress, because we know we cannot eliminate it, right? It's important to suppress the supply of it as well. So thank you for these two examples. Farid, can you please continue with your answer to specific question number 3?
Yes. The next element of this passive corruption is modus operandi. Modus operandi means solicitation and acceptance by public official. But in many countries, in some countries, the solicitation and acceptance by a public official is not considered to accomplished crime. It's considered to attempt to crime. In previous years, the Republic of Azerbaijan is not considered to accomplished crime, and after the reforms in corruption crimes, especially 2006 reforms and 2011 reforms, the solicitation and acceptance of public official is considered to accomplished to committed crimes. And also the next element is purposes of passive bribery. The purpose of passive bribery, including to official act, also to
Farid,
restrain from.
I will stop you here. You mentioned that the modus operandi, i.e. the way in which it can be manifested, implemented, the passive corruption is happening in two ways: solicitation and acceptance.
As acceptance, offer, and promise.
Okay, so what is this third element that you just mentioned now?
Purposes.
Okay, acceptance of offer and promise.
Promise, yes.
Okay, solicitation and acceptance is something which was introduced because of the United Nations Convention against Corruption, right?
Yes.
And the convention is limited to these two types of behavior.
Yes.
What about this third one which you mentioned about the acceptance of offer or promise? Where is it coming from? It is a part of the Penal Code Section 311 on passive
Yes.
corruption, right? But where does it
Yes.
come from? Aytaj, can you answer this question?
Oh, no.
No.
Unfortunately.
Because if you remember during our lecture, I mentioned it, and I specifically highlighted that this section is different. This provision is additional to the requirement of the ANCAC, right? And it was introduced in line and in order to bring in line our legislation with the requirements of the Criminal Law Convention. Criminal Law Convention on Corruption, which is a convention of the Council of Europe, okay? So yes. This is an additional dimension to corruption offense incrimination introduced by the European Regional Convention, okay? So that is one of the significant points, the significance of being a member to this European Convention, okay? Okay, Farid, please continue.
Yes, the purposes of this crime to official act or refrain from enacting. And the next element of this crime is condition including in exercise of his or her duties, also public official duties including. And the next, but in our criminal code, there is no special article of international organization public official of passive bribery, but this is reflected in the United Nations Convention, but in accordance with the Note Part 306 article of Convention of Criminal Code, we may say that this crime, passive bribery, is committed also by international organization of public official, also private public official.
Okay, that's correct, but it's not the subject of our today's lecture, right? International public officials, we will look into this in our subsequent lectures. You mentioned that there's a condition for incrimination, okay? There's a condition for incrimination of passive corruption, passive bribery, and you mentioned that the public official shall act within his or her authority, right? His own public functions. Can you please expand and tell me exactly, like more specifically, what does it mean? Why is it important? And what happens if he doesn't act within the framework of his authority?
First of all, I want to say that previous years, public officials was not expanded in our criminal code, but after the reforms dated 2006 and 2011, the public official definition was expanded in our criminal code. Also, there are some decisions. There is a constitutional court decision dated 29 2013 July, and in accordance and In the previous years, before the 2011, the person who engaged into business without the creation of legal entity, also private public official is not considered public official in the criminal code, but after the 2011 these people are considered public official. Also in accordance with the decision of Constitutional Court, these following person are considered public official. The government employees, also the members of municipalities or military persons in science or warrant officers. In order established by the law vested is considered public official when the person has to write making a binding decision for these persons. Also, the next, in accordance with this decision of Constitutional Court, the employees of local government offices or public states, also the persons engage into business without the establishment of legal entity is only considered a public official when taking actions by him having legal importance, also with modification and emergency and termination of legal relations for other persons.
That's of legal rights. Yes. So in order to sum up and just to add to what you said, it is important in order to consider that the person is actually is committing the offense of passive bribery. It's important that he acts within the framework of the authority which was delegated or vested given to him. If he is not acting within this authority, that would mean that this is not the offense of that he's not the direct perpetrator of passive bribe offense. That would be some other offense. We're not mentioning this now, but we just will say that if it's not within his authority, and as you said correctly, his authority, according to the penal codes, note to section 308, as well as according to the interpretative decision of the Council of the Constitutional Court, these authorities they will be implemented. They shall take the form of some authoritative action when he can actually issue the binding decisions. Binding decisions which other people and organization they have to follow, right? This is the first criterion. And the second one is that, as you correctly mentioned, is that these people, they ought to be empowered, right, in a way that they are actually giving origin, changing or abolishing rights of other people. So if he acts within his authority, then he qualifies as a perpetrator of the offense of passive bribery. If he's not acting within his authority, even if there is an offer, promise, solicitation, acceptance of the offer and promise, right? Even if there's a due advantage, even if he's a public official, right, recognized as public official, right, if he's not acting with his official duties within his authority, then it's another crime which will probably be trade in influence, right? That's the significance of this element, of this condition. Also, you didn't mention there are actually two conditions. There are two conditions for the for the behavior to be considered as a passive bribery. The first one is that he has to act within his official duties, right? Hello?
Yes.
Yes.
Okay, what is the second one, alternative to this? Because Azerbaijani legislation provides alternative to this too. Okay, it goes a bit further than the requirements of United Nations Convention or Criminal Law Convention on Corruption of the Council of Europe. It actually doesn't expand it, so it's not necessary to expand the UN and Council of Europe provisions. But Azerbaijan introduced also alternative type of behavior, which it also considers as a form of passive bribery. What are these two types of behavior? Do you understand my question?
Yes, understand, but couldn't get the alternative action of passive bribery.
Okay, maybe you don't remember it from our lecture.
Passive bribery, 193 article, manipulation of sports.
Oh, that's another issue, which we're going to speak later, okay? But right now we're speaking specifically of section 311. There, in addition to the formula provided by UNCAC and Criminal Law Convention on Corruption, there are two additional types of actions which are considered as forms of passive bribery, right? And these are indulgence and connivance, right?
Indulgence.
Okay. Do you understand this type of behavior? Did you read it in national legislation, and did you understand what it's about? Because it's really important that you understand this. Okay. Well, let me take you, just for the sake of saving time. And it's, of course, it's not a mandatory question for this program, but it's important for you as future specialists, as future lawyers, because the significance comes especially, its significance is manifested in practical terms, okay? Significance is it's in practical terms. Well, the thing is, not all the time you can actually, in practice, let's see, there could be cases where you can actually prove that there's some person who is paying bribes, okay, to public officials. So you have bribes, undue advantage, you have public official, okay, but there's no specific action which can be spelled out, like issuance of a document, giving license or permission, or elimination of some other types of instrument. But you can see that there's clearly a bargain, okay? There's clearly a bargain. For example, I can give you an example that some person, he decides to erect a building, construct a building, right? A multi-storage compartment, a set of apartments for people, and he kind of foresees. Farid, are you here with us? Okay,
yes.
You're here. Okay, Aytaç is here as well. Aytaç?
Yes.
Okay, you're here. Are you following me, right? I'm giving you an example of this indulgence and connivance, okay? There's some person who is going and reaching out, some public official, okay? He's reaching some public official, and when he reaches out this public official, then he is kind of, in advance, he's foreseeing that there could be something which this public official can help him with, okay? So he just goes there, give him money in advance or some different type of undue advantage. And he actually says that when he offers this undue advantage, he's kind of saying that he's counting on this public official, okay? He's counting on this public official to sort of render him some, to connive him, okay? To be kind of his umbrella, a kind of support for him, right? Like we see in mafia type of movies, right? When the mafia guys, they come and tell that if you want our protection, right, then you have to pay, right? And this protection doesn't mean any specific action, okay? Whereas when it comes to bribery, specific bribery, as you see, there's a requirement that it has to be done within, then it should be an action or inaction, right, in the course of implementing the official duties. Okay, did you understand the example which I gave you?
I got something. If you have time, I can say what I understood.
Okay, thank you for that. I can see you that you're a very good time manager, and I appreciate that. Ayten, more or less we covered question number 3. Thank you, Farid, for that. So maybe now it's time for Aytaç to pick another question. Which question would you like to choose?
In sequence, it is a force, I think, yes.
Which question?
Force.
4th question, okay. Let me open it. The 4th question. Okay. Please describe the difference between the bribery and abuse of office. Explain by referring to elements, objectives, and practice of application of these offenses. Please go ahead.
Okay. Bribery and abuse of office are the same actions in intention and perpetrator. First of all, we have two main elements, mens rea and actus reus. Mens rea in these crimes are the same, intentionally. These crimes committed intentionally. Actus reus involves the elements of perpetrator. In these crimes, perpetrator is a public official, and in bribery, also in the abuse of office, and then the incentive can be different. In bribery, the incentive is undue advantage, and in abuse of office, the incentive, I think, is different. It is illegal privilege, according to.
What do you mean, Aytaç? What do you mean that it's illegal privilege? Is it something different in nature from undue advantage?
I think illegal privilege.
Well, let me make it easier for you. You've just described earlier what undue advantage is, right? You said that it's everything that puts a public official in a better position that he was before rendering this type of action in exchange for it, okay? Is illegal privilege something different? So it's not everything? Is it limited category?
I think yes. I understood the illegal privilege and the only privilege in the position, official in the execution of the official duties, getting the privilege. And it is not the tangible things or another monetary funds.
Farid,
it is not.
Farid, do you agree with this statement?
Yes, I agree with Aytaç.
Are you sure that you agree with this?
But under advantage is
well, if you look at the materials, if you look at the penal code, provision 308 and 311, right? These are two sections, which one cover abuse of office and another one covers passive bribery. Both have the same perpetrator, correct? Aytaç was right. She said that public official perpetrate these offenses.
Yes.
Indeed, both they are performing some sort of public functions, right? They perform the kind of duties. The incentive in both crimes is still undue advantage.
Yes.
And it can be anything. Okay, it can be anything. In fact, I should tell you one thing. Okay, before the amendment of legislation in 2006 and 2011 reforms, abuse of office was more in line. This type of offense was more modern and more practical and more progressive than the offense of passive bribery. Because right from the beginning, the abuse of office fully encompassed this idea of immaterial benefit. Okay? And in practice, the Anti-Corruption Directorate's cases, right, criminal cases investigated by the Specialized National Anti-Corruption Agency in the field of investigation, prosecution, and detection, I can tell you that a typical undue advantage in cases qualified under Section 308, i.e. abuse of office, would be the cases when someone, the public official, is doing illegal action in exchange of, by virtue of his friendly relations or certain type of affiliation. Okay, when public official is doing something and the law enforcement agency is not capable even to prove that he actually got something, some advantage in terms of a benefit, like money or some favors, just it could be the case when the public official is actually breaking the rules to show him as a better person, or because it's a kind of friend of his to whom he's helping. Okay, so before these reforms, the 308 abuse of office crime in Azerbaijan, it fully encompassed this immaterial benefit concept. So now at this stage, at the current stage, they both provide as an incentive undue advantage. I'm sorry, but at this point you got wrong, Aytaç. As regards the term which you are using, this illegal privilege, its illegality, it's another feature which I think you will mention later, right? Maybe you want to speak about it now. Okay, you just mentioned that the common features are the perpetrator, public official, right?
Yes.
Also,
action in action for both of them.
yeah.
Okay. Undue advantage also for both of them. Now, you mentioned the common points, right? So at this point, if we just introduce this topic, they look similar. Passive bribery and abuse of office, at this point they look similar. Please, Aytaç, continue and explain us what is the difference now.
Difference is in the actions of the public officials. In passive bribery, the actions are the solicitation and acceptance, and also acceptance of promise and offer. But in abuse of office, the actions, illegal actions of the public official is use of power, use of his or her power contrary to the interests of service, or non-use of power of if in the case the interests of service requires. I think these actions, illegal actions in abuse of power, also involves the common definition, involves generality, because I think the solicitation or acceptance of bribe is also contrary to the interests of service. And now I have an issue in the differentiating these actions, these crimes, because the Article 308 abuse of office involves the generality in actions and has the same elements with the passive bribery in perpetrator and incentive. But I have a difference in the consequence because in Article 308 we have there is a consequence. There should be a consequence, a significant damage to the rights of natural and legal persons and the legitimate interests of society and state. But in bribery, we haven't a consequence. I think a difference is in the consequence part.
Farid, would you like to add something to that?
No.
Okay, I think we need just to add some clarification, okay? We need some sort of clarification in order to make it for you fully understandable, okay, what the difference is, because I can sense from Aitan's response that she hasn't fully settled her mind around this issue, okay, that she's not fully in grasp of the difference between these two actions. The thing is, abuse of office in all cases, absolutely in all accounts, it is about illegal action. So the laws have to be broken, the rules have to be broken in order for action to be qualified as abuse of office. That is for sure. We understand this, right?
Yes.
In passive bribery, it is possible that in ordinary passive bribery, public official is soliciting or accepting offer and promise for something which is legal. Okay, it's not breaking the action for which that undue advantage is promised or offered, or which is solicited for. It's not illegal. It is within the official authority of that, within the official duty of that public official, and it's not against the law. It's just normal type of thing, right? Like issue a license, okay?
Yes.
It would be illegal actions only in one of the aggravated forms of the bribery, okay? When it's solicited for breaking of law by public official, then it's considered an aggravated form. So
yes.
This is one of the differences. In case of abuse
also
of
passive bribery.
Yes, that's what I'm talking about. Okay.
Also.
Passive bribery, it's for illegal actions. So it's an aggravated form of the offense in active and passive bribery.
Yes.
Whereas in abuse of office case, it's always about illegal action. Okay. Again, in case of abuse of office, it's about public official. We do not have to prove that. In case of the passive bribery or active bribery, we have to prove that this action is within the official duties of the public official. Okay. In case of abuse of office, it's not that significant, as the damage which is caused as a result of abuse of office. Okay, so in a sense, the public official is kind of breaking the normal course of duties of his. So he's committing an illegal action which results in the damage. I shall mention to you one very significant issue, that abuse of office is also called otherwise as a safety net for investigation and prosecution of corruption offenses. When investigation is not capable, it's not in a position for some objective reasons, right, to actually build all the elements of the bribery offense, it can optionally go for the easier way, which is the abuse of office, but only in case when it's about illegal actions, right? Is that clear for you now?
Yes, the illegal actions part is clear, but you mentioned, and I saw also, the aggravating circumstance of the Article 311, the illegal actions of public official, bribery in the for the illegal actions. And what's the difference of this circumstance, this aggravating part of this article with the abuse of office? I couldn't get this part.
Okay, I told you that. Okay, let's say only a portion of, only a certain part of passive bribery is for illegal actions. Okay, not all the actions are illegal in the bribery bargain transaction. Do you get that?
Yes.
Okay. When we're speaking specifically about these illegal actions obtained by means of undue advantage or bribery, right? Or bribe, yes. This is a same, it's still an offense of passive bribery. It has to be perpetrated within the official duties of the public official, okay? He has a circle of his duties. He's acting within this circle, okay? He's breaking the rules within this circle, okay? He is entitled to give license, right? He's entitled to give license, but the person does not qualify for this license, okay?
Yes.
In case if this, and we qualify this as exchange of undue advantage, that a person offers or promise or gives this undue advantage, and public official, he either accepts this offer or promise, or he solicits or takes this undue advantage for doing this, for issuing this license, it's fully encompassed within the description of this offense, okay? That's and that's an offense of bribery. But when public official is actually breaking the rules, not necessarily acting within his official duties, but he's acting against the interest of his service, against the rights of people, against the protected interest of state and society, right? When we can show this, right, that yes, he's doing this, he's actually breaking laws, and these actions are actually causing significant damage, or in a more aggravated form, big damage, right, to this interest. In that case, we qualify these illegal actions as abuse of office. Yes. In many cases, in practice, bribery cases in Azerbaijan, I cannot say for sure in other countries, bribery cases in Azerbaijan, they more often originate as abuse of office cases rather than as clearly as bribe offenses. Do you understand this? The criminal yes, case is started not under the section 311, but it's preferably started more under the section 308, abuse of office. And you know why? The reason I explained to you during the lecture. Because bribery offense is what we call formal offense, right? You
Yes.
don't need to show the consequences, the public dangerous consequences.
But abuse
Okay?
of power is not formal crime.
Yes. Whereas abuse of office is material offense, what we call
Yes.
material offense. So you have to show the consequences of it.
Yes.
Okay? When you show the consequence, what does it mean in practical terms? In practical terms, it means that in formal cases, you have to identify the perpetrator, the alleged perpetrator, in order to launch a criminal proceedings. In order to start criminal case, you have to identify a person who committed this offense. Do you understand this? On the Criminal Procedure Code, you can launch criminal case against a person which is called in personam, şahs aleyhine, okay?
Yes.
Or fakta göre, in rem. Do you remember this? Against a person or according to the fact. Well, in case of bribery, you can start this case only specifically against a person. Are you following me? Yes or no?
Yes.
Okay? Şahs barəsində cinayət işi başlanılır. You start the case against a person.
Yes.
It's not possible, absolutely impossible to launch a criminal case in rem in bribery cases. Fakt üzrə rüşvət vermə, it's impossible. If we strictly follow the letter of law, it's impossible. But if we speak about material offenses, i.e. consequences, and we maintain that we can find the consequence, okay, like the consequence is that illegal building was built, okay, a building was built without proper permission granted, okay, we go out and we see that there is a building which was built without proper permission by a competent authority, okay, what we have here? We have consequence. Hello?
Yes.
Aytaç, are you here?
Yes, yes.
Okay, we go out and see that there is a building, illegal building. We have consequence here. Can we launch a criminal case under section 311 or passive bribery? No. If we don't have sufficient evidence, we don't know this person gave bribe to whom, even if he comes and states, he alleges that I paid bribe to this person in order that he connived me to build this building, right? There's no sufficient evidence. The criminal case would probably and most likely will start in rem, fakta göre, under section 308. Okay?
Yes.
That is the significant difference between these two types of actions, two types of crimes. Then subsequently, if we can build all elements of passive bribery, we will requalify that criminal case, the accusation, the indictment, from in rem to in personam, right? And it will be probably under section 311, passive bribery. Can you confirm that you understood this?
Yes, I understood now.
You understand now, okay?
Yes.
So that's what I call safety net, okay? Here, during your answers, both of you forgot to mention crucial key elements, key additional elements, key conditions for the prosecution of passive bribery. And these elements are not so, they are different in abuse of office too, okay? Farid, you went on long about these elements of offer, promise, undue advantage, perpetrator, incentive, right? But you
Yes.
forgot other important, another important dimension to this offense. Do you understand what I'm talking about?
Yes.
Okay. What is it?
Condition purposes.
It's not about elements, okay? It's not about the presence of elements per se. It's about, okay, in reality, crimes do not exist in vacuum, right? You cannot dissect them into elements. You dissect them into elements just to understand it, just to prove bit by bit, okay? But these elements, they don't exist separately. They are interrelated, okay? There have to be links between them. What I'm talking about?
Causal links.
Causal links, exactly.
Links, yes.
Okay.
Inaction, action.
Okay, we have to prove in case of I touch. I'm coming back to you now.
Okay.
I'm coming back to you now, and I want to put you on the screen. Look, in passive or active bribery cases, we have to prove, okay, links. We have to prove that undue advantage changed hosts, right? It changed hosts, and that undue advantage due to payment, by virtue of payment of undue advantage, the person affected the behavior. The person affected the behavior of public official, right? And
Yes.
instigated him to commit action, whether legal or illegal, okay?
Yes.
We have to prove this. The causal link.
Causal.
Okay?
Okay.
The casual or causal, whatever you say it, okay? The thing is, there's a apparent person, who is actually trying to affect the behavior of a public official in both active and passive bribery, right? Whereas the logical stress in abuse of office is in another place. It's from another angle. It's actually the initiator of illegal behavior is public official who is abusing his office, okay? You don't need to link this external person to the public official. You concentrate on the personality, you concentrate on the person, sorry, not personality, but person of public official. So he is in the center, he's in the center of this offense, okay? Okay, which other, we don't have much time left, we have only 10 or 15 minutes. Which other questions would you like to look into?
Questions. I have a question with the difference of fraud and the corruption crimes, especially misappropriation of official powers.
Fraud is crime against
This
property.
is question number 6, right?
Yeah, number 6.
Maybe.
6.
Do you see it on the screen?
Yes.
Okay.
Last question.
The question, actually the offense of fraud, which is under 178.2, before going to answer your question, before we discuss actually our question together, it will not only be me speaking, I hope you will contribute equally. Well, you mentioned, I touched in the beginning, that corruption crimes are encompassed in chapter 30, right?
Yes.
But this crime is against property.
And you mentioned this offense of embezzlement, which is outside of this chapter, and it's in It's in section 179, okay? It's in section 179, which is considered an offense against property, right?
Property, yes.
Yes, Farid, you mentioned that. The thing is, not only this chapter and this section of the penal code, right? There are many chapters, many sections in the penal code which can be perpetrated by public official. And although in our legislation we don't have specific definition of corruption offense, right? What we have here is we consider that if offense is committed by the public official, then it can be considered corruption offense in a general way, in a bigger way, right? In a wider perspective. So when we speak about, I'm trying to switch on to the cameras, but it's not operating, okay? Okay, I want to, okay, it doesn't work. Anyway, I need time to adjust to this. When we speak about 178.2, it's a fraud committed, fraud or swindling, depends on how we translate it from the original language, committed by public official, okay? And here I specifically put these two articles of 178, fraud by public official, and 312-1, okay? Which offense is this?
312-1,
yes.
Trade influence.
Trade in influence, okay?
Yes.
So
first, differences of this crime.
Okay, go ahead.
This crime is defined as object of crime. The object of fraud crimes is protect property of persons, but the next crime, corruption, influence trade, the main object
trade
of
in influence.
Trade in influence is the main normal activity of states, local governments.
Okay, the thing is, this is a tricky question, okay? Tricky question, which is even problematic for law teachers and practitioners. The thing is, this section 178.2 and other points, other items like 3 and 4, they have their own history. They existed in our legislation for a long time, okay, and they have a very great big jurisprudence. They have been used many times, whereas this section 312-1 on trade and influence, it's new, okay, it's new. So in many cases, in practice, the Azerbaijani legal system puts a difference, which I don't agree with. I shall point from the beginning. I'm against this position, but this is the official position of the application of law in our country. Well, if the person is taking money, we both know that here in both these sections, the money is taken or is offered to not the people who are making decisions. Okay?
Okay.
Not to people who are making decisions. When we speak about trade and influence, this is a kind of person who is taking money, soliciting or taking or accepting the offer and promise of money in order to use his real or supposed influence. So his influence can be real or supposed. He can suppose that he has influence or he doesn't have that influence. So it's not existing in reality. He has no means to influence that person, but he gets money to affect his behavior. This partially is compatible with the definition of fraud. When the person is getting hold of the property of another person by means of deceit. So in Azerbaijani case law, in our jurisdiction, if a person is taking money for something for which he is not entitled to do, he has no authority to do, and you remember this element of passive bribery, to act within his official duty, right? So if he's not acting within his official duty and he's still taking money for the implementation of some action or inaction, then if you manage to prove that his intention was to obtain the property by means of deceit or abuse of the confidence of that person, then it will be qualified under section 178.2 or 3 and 4. Okay, is that clear?
Yes. Yes.
Okay.
Yes.
When we consider that the person is actually taking money and he really does have means, that he really has means to affect another person's action, and we can actually build this link, right? How is this happening in the course of investigation and prosecution, right? If I'm taking money, for example, and the investigation can prove that I'm taking money to influence the behavior of some official who is my friend or my relative, okay? If the investigation manages to build this link between us, okay, then it will be qualified, the same kind of actions, it will be qualified under section 312-1. Okay? Do you understand it?
Yes. Yes.
That was what I actually expected from you to figure out. I didn't mention it during the lectures, but I presented to you these offenses and I was thinking maybe you find it out, but I suggest that you go back and read this commentary, interpretation of penal code, okay, these two sections, and you find out in greater details what I mentioned to you, okay? So there is a person who is offering something of value, okay? Here, unfortunately, we don't have the concept of undue advantage in section 178, but for the purpose of this discussion, we'll think that it is there, okay? We'll speak about something of value. A person gives something to another person, and if we can prove that he was able to affect the public authority, right? That he had the means to affect him in any ways due to his real or supposed influence. In that case, then there is an offense of trade in influence. If, however, the person is giving something to another person, and right from the beginning we understand that this person didn't have any means to influence public authority, then it's fraud.
Yes.
Is that clear now?
Yes, it is clear. But supposed influence isn't clarified, I think.
That's a very good question. That's a very good question, which I will bear in mind when I'll be grading your participation. That's an excellent question. That's where I don't agree. I think that, well, don't take that I'm fully against this established position. What I described to you earlier, I agree in part with it, in part. My disagreement emanates from this specific term, the supposed influence. Okay? The supposed influence actually is something that is, in fact, similarity, draws some similarity with fraud, okay? Supposed influence, it can be proved, but it cannot be proved as well, okay? It's a very subjective issue. If the if I maintain that I can influence the that public official's behavior, give me money, I'll influence his behavior, right? If I can prove, if investigator accepts that I have supposed influence, right, then it will be qualified as trade in influence. Okay?
Okay.
If he doesn't accept my argument, okay, or if he doesn't consider it that way, then he qualifies it as a fraud. Okay? Well, let me give you an example. Let's say somebody's child is studying at the same school as the child of some very big public official. And this person is getting money from someone, and he says that I can resolve this permission, this license, I can obtain this license for you because our school children study at school together. Okay?
Yeah.
If
Yes.
in the course of investigation I say that yes, I said this, okay, God forbid, I have no intention in engaging myself in illegal activities, right? But let's suppose it's me. If I say to investigator or prosecutor or judge that I had supposed influence upon this person because we had some kind of connection, well, in the eyes of investigation or prosecutor or judge, did I have this influence? Well, if he tries to pull some records of mobile communications, right, he can maintain that, oh, there was a communication and they had this agreement between them. He could ask him for this favor, right? Then he can say that, yes, it was a trade in influence. But if there's no communication, right, once in a while I go and speak to him and there is no means to prove that I have any connection with this person and I cannot influence his behavior. In that case, it will be qualified under section 178. Okay? So this element of supposed influence, it has this this concept of supposed influence, it has certain subjective element to it. And unfortunately, our legal system is not very volatile, it's not very effective in dealing with these subjective elements. Do you understand me? We are now expanding into this very philosophical and legal philosophical field, which is, do you understand this? It's a topic of discussion rather than some practical issue. But it's good for you to go into theory, okay? I think by the time you start fully practicing law, this whole situation can change, and I want you to be prepared for this new situation, okay? Okay, guys, I think we're run out of our times. It's 1 hour and a half. Although Teams doesn't limit the duration of our seminar, I don't want to abuse your time as well. Thank you for participation. I know it's difficult for all of us to do this in a distant mode. Thank you, and I highly appreciate. You both did very well, and I think you deserve high grades. Unfortunately, Ravshan Garayev did not attend our seminar for the second time, and I'm not sure whether he's listening the online lectures. But thank you, and see you next time. See you next time during our seminar. Please look into the sources, into the files in your Teams. I uploaded few books and materials. They're useful. When you have time, just read them, because written exercises are also ensuing. Okay?
Yes, sir.
Okay, at this point, I'm just saying bye to you. Remember, stay at home. Stay at home.
Be optimistic.
Be optimistic and
Protect yourself.
don't waste your time.
Don't hear.
Okay. See you next time. Bye-bye.
See you soon.
See you.
Bye.